Welcome to Fairy Tale Access, where the head fairy's quest is to prove that fairy tales do exist in actual time, rather than once upon a time. Together, we will unravel the heroes, young and old, who turn dreams into reality. These are the people who still believe in happily ever after. The discoveries will bend even our most cynical non-believers into believing in fairy tales. Welcome to Fairy Tale Access. Today, we're going to discuss divorce and family law options if you are going through a divorce. And with me to help us understand the process, I have attorney John Cameron. Thank you for joining us today.
Happy to be here.
Thank you. So can you tell us what the divorce process is like in New Hampshire? Is it a quick option?
Well, it has changed. It used to be faster than it is now, but it depends on the route that you take as well. If you take the litigation route, it could take you a couple years to get divorced. That wouldn't be unusual. If you take a route that avoids litigation, even if you do hire attorneys and you're able to avoid litigation, you might be able to get through a divorce in 6 or 8 months. It's being in a court process that tends to slow the divorce itself down.
So other options outside of the courtroom would be mediation?
Well, maybe a step before that is one way to speed it up is there are 2 different ways primarily that you would file for divorce. One is you would file an individual petition for divorce, and that would require the other party being served. The old days where a sheriff used to drive up to your house, knock on the door, and serve you your divorce papers. They've streamlined that process a little bit now in that you can be served by certified mail, you can receive a notice from the court and go into the court and pick up your papers, things of that nature. Or you can file a joint petition for divorce where the process starts the minute the paper hits the court with both signatures on it. So you don't have to wait 10 days or 2 weeks or whatever the period of time might be in order to get the process actually started.
So that's a joint petition for divorce?
That's a joint petition for divorce, yes.
And do you have to agree on everything if you have a joint petition for divorce?
No. All you've agreed upon is that there's going to be a divorce.
Oh.
That's when the work starts.
That's when the work starts.
Right.
So what are some ways that they can bypass the court system and get the divorce done quicker?
Well, there's probably the easiest way is to agree on everything. You know, you would call it conciliation. The parties may sit down. There are ways that you can get information to help you through the process. There's a book written by attorney Honey Hastings called the New Hampshire Divorce, I think it's called the New Hampshire Divorce Handbook, that people can buy for a relatively low amount of money, and it'll basically lead them through. Do it by themselves. The paperwork that the courts have now been offering basically involves filling in the blanks and checking boxes. And that makes it very easy for the parties to work through what, if there's children, equates to 9 separate documents that have to be filed with the court in order to get divorced, including the petition for divorce.
Wow, so that would be something like a parenting plan that gives them a list of options and how to split up holidays and who's responsible and...
Exactly. That there are the 2 main documents that get negotiated, if you will, or that require agreements are the parenting plan and then a document called the decree of divorce. And that's how you divide up your property, your personal property, and your real estate, and your cars, and your collections, and everything else that might be involved.
Wow.
But
I'm sorry,
but you also need financial affidavits. You also need something called a uniform support order. You also need a child support guidelines worksheet if there are children and things like that. And so in the final analysis, you've got quite a few documents that you have to file with the court.
What if the parties agree on everything and because these records become public, they do not want to hand in the financial affidavits or their financial history they've agreed on, that neither party is going to pay child support, or they've agreed on what child support would be? Would they still need to go through all of those documents?
Everything has to become a court order. And so the documents get filed with the court so that there ultimately is court enforcement of those documents in the event things break down in the future. But the good news is financial affidavits are now, I'm going to mess up with the word, but they're not for public view. They're under seal.
Oh, they're all under seal now?
When they're put in the court file.
Okay, great. And are there filing fees for divorce in New Hampshire, or is it free?
Yeah, no. Free?
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 Not in New Hampshire.
The current filing fee for a divorce is $205. And if you've got children, it's $207. Don't ask me why kids are only worth $2, but...
For the extra form?
Maybe so.
Well, and how are modifications handled once the divorce goes through? Is it the same way?
Well, I'm going to give you the lawyer answer first.
Okay.
It depends. If you learn when to say it depends, you're unofficially a lawyer.
Okay.
There are parts of a divorce decree that are modifiable, parts that are not. Generally speaking, property distribution, for example, who gets the house, who gets the cars, who gets the bank accounts, who gets the retirement accounts, and so forth, are not modifiable once the divorce has been granted.
Okay. What about alimony?
Alimony and child support would be. And they're modifiable. Let's talk about alimony first. Alimony can be altered in the future depending on whether or not there's a significant change of circumstances. For example, if one of the couple is required to pay alimony to the other and they lose their job and they were supposed to be paying $1,000 a month or $500, whatever the number might be, they don't have the ability to pay alimony. And so it can be suspended, it could be terminated, depends on the circumstances.
What if neither party asks for alimony at the beginning of the divorce? Is there a statute of limitations on how far forward they can go back to ask for alimony?
I think it's appropriate to call it a statute of limitations. There's a 5-year time frame in which somebody can ask for alimony. And currently, if there's a divorce or legal separation, and no alimony is requested then, but a year and a half down the road, or 4.5 years down the road, or 4 years and 11 months down the road, under 5, they realize that they need alimony, they can go back and ask for it. Once you miss that 5-year or go over that 5-year limit, then you cannot go back and ask for it. However, if you do get alimony at the beginning, and let's just say it goes for 3 years, from the date that it ends after 3 years, you still have that statute of limitations. You get 5 years to go back from the date it ended.
Okay.
So you actually have, theoretically, you might have 10 years of exposure to alimony at a maximum. You know, you might get alimony for 5 years, and then you may let 6 months go by and you go back and get it again. But it has to be dependent upon whether or not the person has a genuine need and whether the person they're asking it from has the ability to pay it.
Okay. What about child support? How do they determine that? Is there a calculation?
We currently have guidelines. And if you look at the guidelines in the booklet that is available in the courts, it kind of looks like a tax table And it depends on what the combined income of the parents is and the number of children, and that's a guideline number that people are to follow, and it's generally predicated upon if one parent is a primary parent and the other parent has maybe 20, 30, 40% of the parenting time, maybe 20 or 30% of the parenting time, that parent with the less amount of parenting time is likely to pay the guidelines amount. But the court has the discretion to be able to choose a different amount depending on what the circumstances might be. And child support is modifiable, again, based on a significant change of circumstances. If, for example, the parent paying child support gets a decrease in salary or an increase in salary or income, then it can be modified on that basis. And it can be reviewed automatically every 3 years whether there's a change in circumstances or not.
Fantastic. So that would help with teenagers as they get older and they're into sports, having it relooked at every 3 years.
Well, it does, yeah. But the thing is, the child support is based on income, and it's a percentage of gross income. Well, it's actually, the number they put into the calculation is a gross income number, but it deducts certain things that might otherwise need to be deducted, like the Medicare payments, the tax payments, Social Security payments. So what is actually happening is the percentage is a percentage of the net income, not of the gross income. And so you're kind of locked into a number. But my understanding is, I believe it's going to be the 1st of July of this year, they're coming out with, there's been legislation passed, there'll be new child support tables that are going to look at the numbers a little bit differently. For example, if somebody's earning $1 million a year and they got 2 children, which would be a 30% of net income calculation, and if the net income is $700,000, it's kind of a stretch to say that you need $210,000 to raise a couple kids. And so they're going to take some of those things into consideration and make theoretically at least, make the calculations a little more realistic.
But is that fair when that's the standard of living that the family has come to expect?
I think the question really is, even under that standard of living, does a child require that much money, you know, to get them through high school? And I mean, whether they can drive a Porsche to high school when they're a junior or something like that, I suppose, but it's hard to say. But I think they're trying to put a little bit more reason in it, not necessarily cut it out altogether or say, no, you only get the same amount of child support that a family with a combined income of $50,000 get. That's not what it's saying, but it's saying that maybe there is a reasonable amount that we really got to take a better look at.
Okay. And then you mentioned separation agreements. So do people still get separation agreements prior to getting a divorce, and what would be the purpose of a separation agreement?
Well, under the law, we have legal separation and we have a divorce. People do voluntary separations all the time. I'm moving out, we're going to get divorced, I've got an apartment, see you in court, or whatever, or let's see what we can do to work out a divorce is the right way to say it. But some people do choose a legal separation, and in my experience, there are 2 or 3 reasons why they might do it. One is religious reasons. One of the parties, or both of the parties, doesn't believe in divorce, but they're okay with a legal separation. In a legal separation, you cannot remarry, and so that's one of the factors that needs to be considered. I had a case that I mediated where, at the time at least, the wife was on the husband's medical insurance. She was a heart transplant recipient. For her to be able to get medical insurance as a single person after the divorce would have been almost impossible. I don't know. She didn't know how she was going to do it, and she wasn't old enough to get into Medicare or anything of that nature. I believe they were in their early 50s, and so I think there still is the opportunity for somebody to stay on the employee spouse's health insurance in a legal separation. There may be some exceptions, and that might be another reason to do it. And a third reason might be they're just really not sure that they want to be divorced, but they do want to be apart. The interesting thing is, in legal separation, you go through the exact same process as a divorce. You divide property, you create a parenting plan, or whatever you might need to do. You're just still married and probably living separately.
Wow. So when is mediation a good option? It sounds like it was there.
Well, you're asking somebody who thinks that mediation is a good option just about all the time.
Does it keep you out of court?
It can, yes. Now especially because you don't have to go to court for a final uncontested hearing anymore. So if you can file all your paperwork, you check off a little box on the last page of the decree, and it says, we waive our right to attend a final uncontested hearing. And you get your divorce decree in the mail. You never have to show up in court other than to file the paperwork. And I do a number of mediations like that, a lot mediations like that, where the parties don't file any paperwork. They don't even start the divorce process until we finish the mediation. All the paperwork is completed, all is done, including the joint petition for divorce, and all filled out. Somebody walks into the court, pays their $205 or $207, and they're there for 5 minutes while the clerk makes sure that everything is correct, and they're done. Divorce is done.
Well, but what if one of the parties is pro se and does not have an attorney representing them? Is mediation still an option that the parties could consider?
The majority of the private mediations that I do not include any attorneys whatsoever. There are mediations that I do that have one attorney and not another, and of course then there may be an attorney on each side. So it's really a comfort level for that particular person.
So are all mediators not attorneys?
That's correct. Not all are.
Oh, okay.
Yeah. In order to be, there's a certification process in New Hampshire to be a certified family mediator. You don't have to be a certified family mediator in order to be a mediator, and we have a lot of, I would say, generally effective mediators that have not gone through the certification process. But in order to mediate in the court, in other words, to be assigned by the court to mediate a case, you do have to be a certified family mediator.
Okay. And what about case managers? As soon as somebody, say people file for divorce before they speak with an attorney and they're just filing the initial paperwork, and they get a case manager assigned by the courts now, what's the difference between a case manager, a mediator, or maybe a parenting coordinator? Aren't all three of those basically the same thing?
No, not at all. A case manager is a court employee.
Okay.
They basically do just what the title says. They shepherd the case, monitor the case. There are other clerks that are also responsible for how the case proceeds, but their responsibility is to make sure the case gets through, notices get sent out, the right paperwork is submitted, they get assigned to mediation if appropriate, things of that nature. They're a court employee.
Okay.
A mediator is not, and by the way, a case manager is not a mediator. They don't mediate the cases.
They just let you know what paperwork you need, or?
They'll sit down and they'll go through the paperwork with the parties on many occasions and help them understand the process. There's also, by the way, something, it's kind of hard to say that it's new anymore, but the courts have instituted something called a first appearance. that's when the parties, and sometimes with their attorneys, and attorneys are not required to attend, but it is the first function that a divorcing couple will partake in the court system. If they're if they filed a petition for divorce and have not chosen to do mediation before filing any paperwork. I'll just go back a half a step. If you prepare all of your paperwork with a mediator prior to filing anything, and the same thing with collaborative law, if all the paperwork is all done, all completed, all filled out, and then it's filed, you're essentially starting and kind of ending the divorce process in the same fell swoop. But when you file a petition for divorce and you now are into the court process, the first thing you go to is called a first appearance. You are given a lot of information about what the court process is going to be like. You will meet with the case manager. The court or the case manager will determine whether or not mediation is appropriate. And generally speaking, unless there's certain circumstances, for example, a history of domestic violence, a divorcing couple with children are going to be sent to mediation pretty much automatically.
Oh. So if they go beforehand, they can get everything done.
Absolutely.
And avoid at least one hearing in court?
At least one, and conceivably more than one. You almost might say that pay me now or pay me later. If you've got children and there's no particular reason why you should not be sent to mediation, you're going to go to mediation either through the court or without going to the court. The advantage of going before is that you can control the mediation process more yourself, because with the court, they're going to schedule you for a day. It may or may not be a convenient day. They're going to schedule you for 2 or 3 hours. If you can't accomplish everything in those 2 or 3 hours, they're going to schedule for another mediation and so forth. But if you choose mediation prior to going to court, then you can really control the time, the place where the mediation occurs, and get things done perhaps more efficiently. But the good news is the courts endorse mediation too.
Oh, good. And does the mediator sign off on any of the paperwork that you submit that you were actually in mediation, or do you get a certificate of mediation? I passed. We agree.
Not really.
No.
Only if it's court appointed. If it's court appointed mediation, the mediator is required to file a report, and the report is very simple. Was anything accomplished? If not, what do you want the court to do next? If yes, when do we get the documents? It's very, very straightforward.
Okay. And then when would a parenting coordinator come into play?
Okay.
Because I think these are 3 types of people that are in the divorce process that people are getting confused about what their roles are.
Okay. Can I also mention the term collaborative law in my answer?
Absolutely.
Because what we're talking about is alternative dispute resolution. And the term means, ADR, alternative dispute resolution, means alternative to litigation. Mm-hmm. So mediation helps you avoid litigation. Litigation meaning you're in front of a judge, you're arguing your side, and the other person argues their side, and you figuratively throw things at each other and call each other names, and not necessarily, but I mean.
So in mediation, do you just sit on opposite sides of the table sometimes, or do you go through your mediators? Do you both have a mediator, or is there one mediator? One mediator.
Okay. Helping the 2 parties negotiate a final agreement for parenting, for division of property, and for things like child support or alimony.
And do you deal with their lawyers as well, or does that muddle the situation?
Only if they have attorneys. I'm more than happy to have attorneys participate if they want to. Sometimes the parties are very anxious about the process, and the attorneys can bring a little bit of stabilizing effect to the table. They can help if there's a lot of emotion involved, and divorce is one of the top 3 emotional creating circumstances or events, right? then they can help people understand when they're not able to understand things that may be for their best interest, because the mediator can't do that. The mediator is there to facilitate the process, facilitate the negotiation, participate in brainstorming of different ways that things might be worked out, but they cannot give legal advice. Even if they are an attorney, they cannot give counseling. Even if they might be a mental health professional, they're there to ensure fairness, to ensure that enough information is shared so that informed decisions can be made.
Okay. So parenting coordinators and collaborative law, does that bring in more professionals?
Yes.
Okay.
And mediation might as well. There may be a mediation where you might need to bring in a CPA, or possibly a mental health individual, or a real estate agent, so that we can get the kind of information we need to make decisions. Collaborative law is generally a pre-divorce or divorce process kind of an effort, in which the parties have attorneys, but they sign a collaborative retainer agreement that says that we're all going to work together in order to ensure that this divorce gets settled, and we are not going to litigate. We're not going to go to court. And they sign the agreement that says, if anybody says, I'm going to court, and makes that decision, then the attorneys are required to withdraw from representing these individuals. At this point, they may not have filed anything. They probably have not filed anything with the court. They're most likely working with the parties prior to anything filed with the court, but they can still work with the parties after something has been filed with the court. But they're there to work it out without litigation. Collaborative law is very much a no litigation process, alternative dispute resolution process.
And is that new, or has that been around for a while and it's just being more widely used now?
It's growing. I'm trying to think. I went through, it's been about 10 or 11 years when I went through my collaborative training for the first time. And it was in existence for probably 4 or 5 years, growing. Started in Minnesota, and it's really spread throughout the country. In fact, I understand that there are some locations, I know of one in Canada, where I would say 90–95% of the divorces in this particular area are all done collaboratively.
Would prenuptial agreements fit into the collaborative law scheme? Could you have that as part of a prenuptial agreement, so that if it ended in divorce, unfortunately, because second marriages usually do, would they be able to put that in? Or
I think, I'm not sure how to answer that question. I think it could be put in. Off the top of my head, I'm not sure that it would be enforceable, because there are these certain constitutional rights that we have that we can't force somebody to take a particular direction if they have the freedom to choose, and if they have the freedom, if they decide they're going to take the litigation route. And somebody might say, well, why would you litigate anything if you got a prenuptial agreement? Well, it might be because you're also challenging the validity of the prenuptial agreement. So, hard to say. There's not necessarily any easy answers to some of these questions.
That's true. Are there any other non-court alternatives?
Well, you did ask about parenting coordination. And parenting, I better finish this answer first. Parenting coordination is primarily a post-divorce, when there's already been a decree, and the final hearing, if there was one, has ended. There are a certain class of individuals who we refer to as frequent flyers, who are in and out of court a lot after the case has been resolved by the court, because there's a high level of conflict. And parenting coordination is, again, an alternative dispute resolution process that is intended to deal with the conflict and help the individuals get over it, so to speak.
Get over it, stay out of court.
Yeah.
Adhere to the parenting plan, maybe?
Well, that's primarily it. It's focused on the parenting plan, and a parenting coordinator has 3 general responsibilities, or 3 levels of attack, you might say. The first is to help educate the parents in 2 areas. One is parenting skills, and the other is conflict minimization, or how to handle conflict, or how to stop the other person from pushing your buttons, which really means how to control your reactions when you think the other person is pushing your buttons.
Oh.
The second level is as a mediator. And when the educational process isn't bringing resolution to some disagreements, then you mediate, but still give them the power to make the decisions themselves as a mediator. And then when all else fails, there is the ability for a parenting coordinator to make the decision as an arbitrator. Now, this is where it gets a little bit sticky, because there's only a narrow area in which a parenting coordinator who's not a judge can make decisions for the parties. And it usually is just some really small kinds of things, like, can we change the time of the exchange of the children to 6 o'clock from 5 o'clock? Those kinds of things. Can I start my vacation a half a day earlier with the kids? Things like that. They can't make the major decisions that a judge would normally be required to make. And there's some couples that sign up for parenting coordination that will not agree to the parenting coordinator making decisions because they feel that they would rather still prefer to have access to the court to do that.
Right. But I think as a parent, wouldn't you want to not have the judge make any of your decisions? Because honestly, how does a judge really know your family and the dynamics? Isn't it better if they could mediate and work it out?
There's a problem. The problem is called human emotion. Mm-hmm. Human emotion and logic are inversely proportional. Okay? And the irony of it is, when people get married, it's usually a really emotional kind of a thing, right? We're in love, we're going to go to Nirvana together and walk into the sunset or whatever. And when they're getting divorced, it's also a huge emotional experience, except we've gone from positive emotion to negative emotion. And we're still dealing with emotions. We're dealing with anger, we're dealing with hurt and things of that nature. So sometimes, if not much of the time, it's not as easy as saying, don't you just want to stop going to court? Well, no, I don't, because I want to get even, or something of that nature.
That's true. So mediation is one of the better ways to get past all of that.
One of the things that mediation helps provide, and I mediate other kinds of cases besides divorce or family cases, it has an opportunity, at least, and in many cases it actually does, help preserve to some degree the relationship between the parties. If they can sit down and spend 3, 4, 5, 6, 8, 10 hours, whatever it might take, to mediate a divorce, to agree on how they're going to raise the children together after the divorce, and so forth, they've already set the standard, or at least a beginning point, for cooperation thereafter. If you go to litigation, you are entering a process that is designed to be competitive. Mm-hmm. And I think parents really need to be cooperative, not competitive.
That's true.
Even if they're no longer together, it shouldn't matter.
Absolutely. And I guess my last question for you today would be, let's see. I just forgot. I can edit this part out, but what was the other thing?
Hey Denise, we'll just start up with my last question for you today is,
Okay, I know what it is. Okay.
Thank goodness for editing, huh?
I know. My last question for you today is, whoops, sorry. I wasn't picking up. Okay. So I guess my last question for you today, Attorney Cameron, would be, what's the main difference between a parenting coordinator and a guardian ad litem? Does the guardian ad litem just there for the child's interests and doesn't go the extra lengths that the parenting coordinator does, or are they pretty much the same thing now?
No, they're not, and I appreciate you asking that question, honestly, because it's there's quite a difference. A guardian, I am a guardian ad litem as well. A guardian ad litem is there to represent the best interests of the children. Parenting coordination, even though the effort focuses on the parents, the purpose of it is to also take into consideration the best interests of the children. But guardian ad litem is a relatively limited effort, and you're sometimes people like to use this term, sometimes people don't, but to a certain degree, you're kind of the eyes and ears of the court. In other words, a judge doesn't have the opportunity to spend hours talking to the children or talking to individuals that know the parents, that know the children, so that they can make a determination as to what might be in the best interests of the children when it comes to what the parenting issues ought to look like when the divorce is granted. And of course, a guardian ad litem doesn't have to be involved just in a divorce. It can also be when there are parents that file a parenting petition that were never married. Mm-hmm. So the focus is on the children, and an evaluation is done as to what would be in the best interests of the children. Recommendations are made to the court, and through a report, either a verbal report or a written report, that the judge may or may not take into consideration as far as the input from the guardian ad litem in making a decision about what's going to be best for the kids. I hope I didn't throw too many words in there. A parenting coordinator, on the other hand, does not have a relationship with the court, although they may be brought into court as a witness at some point. The relationship with the parenting coordinator is with the parents, working with the parents to try to get them to be more cooperative. A guardian ad litem doesn't do that, although a guardian ad litem could make some recommendations like couples therapy or a parenting class or something of that nature that would maybe accomplish some of those things. But a guardian ad litem's job ends when the case ends. A parenting coordinator, for example, my contract with the parents is an 18-month or 30-hour period of time, whichever ends first, renewable if the parents choose. Mm-hmm. And I work with those parents for that length of time, helping them understand skills, possibly sending them to a parenting class for high conflict parents, or things of that nature, bringing resources to bear so that they can be better co-parents despite the fact that they're no longer married. I hope that makes enough of a distinction.
Absolutely. So it looks like the best way to get divorced is to not have a high conflict divorce, because there's so many players that these divorces must be excessively expensive, and they're spending more on litigation than they would be taking with them when they split if they were to go to mediation or try one of the new collaborative law options, which we'll talk about a little more in another segment. But I want to thank you very much for being here
Oh,
today.
you're welcome. Thank you.
And would also like to know what your favorite book is of all time.
Oh, man. And in the moment, I'm reading Lincoln, the new book about Lincoln. What is it? Rivals. Team of Rivals.
Team of Rivals.
Yeah, loving it.
Really?
Loving it. I'm basically into nonfiction. As boring as it might sound, I'm also reading a 2-volume history of Poland because I have Polish in my family, and I've got. There's no one book. I love autobiographies. I love biographies. I love history books.
Fantastic. So if people need more information about mediation or a divorce, what's the best website to get information from you about it?
Well, I'm more than happy to have somebody track me down. My mediation website, or my one points to the other, so I can be reached at John Cameron at cameronlaw.us. There's also some information about mediation at the state website. If you go to the State of New Hampshire website and do a search for Family Mediation Certification Board, I'm sorry, I can't remember exactly what the extension for the State of New Hampshire is for that. There's quite a bit of information there about certification of mediators and a list of certified mediators in the State of New Hampshire if somebody needs to contact somebody for that purpose.
Fantastic. Well, thank you for your help again today. I appreciate it. It was nice to see you again.
Thank you very much.
My
Appreciate it.
pleasure. And if you have questions, keep Googling, ask more questions, contact an attorney, and find out what your rights are. Until next time.